Securing and maintaining safe housing is certainly a key concern for survivors and an essential step towards safety and independence. We are very excited to welcome our presenters from Community Legal Aid, Jennifer Dieringer and Amanda Winalski, who will speak about housing rights for survivors. Jennifer is the managing attorney of Community Legal Aid's Hampshire, Berkshire, and Franklin County offices, specializing in family and housing law, and has extensive experience as an attorney, educator, and author. Amanda is a staff attorney focusing on eviction defense and subsidy preservation. Welcome, Jen and Mandy. We have an hour for this webinar, so Jen and Mandy will present for about 45 minutes, and then we will have a question and answer period. Please use the question feature on your side panel on the right-hand side if you have a question, or if you're having any technical problems. You can write us with questions anytime during the presentation, and we will send them to Mandy and Jen to answer at the end of their presentation. Whenever issues related to survivors of domestic and sexual violence are discussed, any of us may experience personal responses to the discussion. So we would like to remind you that it is important to give attention to taking care of yourself. So we're going to start with a polling question to see who is with us this morning, and then turn it over to Mandy and Jen for their presentation. Thank you again so much for joining us, and stay tuned for future webinar presentations in our Economic Security for Survivors series. So here is our first poll question, which is, what type of organization are you affiliated with, if any? And I'm going to launch that, and the poll is now open. If you could click what type of organization is most close to what your situation is, that would be great. So, got a couple more people who are still voting, and then we'll close it and show the results. Okay. All right, I'm going to close it now. And the results are that 56% of us are from domestic and or sexual violence programs. We don't have any from housing programs or legal services. 13% from a government agency, and 31% are from other organizations or not from organizations. So thank you very much. So we have an idea of who our group is this morning. Okay, I am now going to turn it over to Jen and Mandy for their presentation. Thank you so much.
Hi, this is Jen. I'm just doing a test. Barbara?
Oh, yeah.
You can hear me?
I can hear you, and I can see your screen.
Terrific. Hi, everybody. This is Jennifer Dieringer. Thank you, Barbara and Amy, so much for having us today. We're delighted to be with you all. I want to start off by talking a little bit about Community Legal Aid and who we are. I know from the list of participants that many of you know us and work closely with us and even advise us. But for those of you that don't, Community Legal Aid is the sole legal aid provider for civil legal services in the 4 western counties, Berkshire, Hampden, Hampshire, and Franklin, as well as central Massachusetts, Worcester County. We were formerly LACM in Worcester and Western Mass Legal Services in the western counties, and we merged in 2011 to become Community Legal Aid. We serve low-income folks, and what that means for us eligibility-wise is that families can have income up to 200% of the federal poverty guidelines, or if they are age 60 and older, which is our elder category, there are no guidelines that apply for financial eligibility. So we provide a variety of civil legal aid services, but of course for today we're focusing on housing services. And what we provide in the housing realm is eviction defense, foreclosure defense, termination from Section 8 programs, fair housing work, and EA shelter cases. Since you all are from the Worcester and West, I'm going to focus a little bit on those housing courts to say that in Western Massachusetts, the main housing court is in Springfield, and then there are satellite courts that sit once a week in Hampshire, Franklin, and Berkshire. And then in Worcester, the main court is in downtown Worcester, and there are satellite district courts that operate in Dudley, Leominster, and Marlborough once a week. And we provide support and assistance to tenants in all of those courts. I want to start by talking a little bit about the basics of eviction, just so everybody's on the same page. And the basics also include some good news, and that is, and this can be very helpful for tenants who have received an eviction notice for the first time and are very understandably very scared of what's happening. The good news is only a judge can issue an eviction order, or a judgment is what we call it. A landlord cannot use any self-help to evict, and what that means is that unless the landlord has an order from the court, it is illegal for a landlord to move a tenant's belongings out of an apartment, to change the locks on the apartment, to shut off or interfere with the utilities in any way, or to in any way interfere with the use of the apartment. If a landlord does that, the tenant does need to go to housing court to make the behavior stop, but that is clearly illegal behavior, and without an actual court order, the landlord cannot do any of those things. A little bit about the general requirements of eviction, because there is a process that landlords have to abide by. First, the landlord must properly terminate the tenancy. And what that means is they have to start with something called a notice to quit. The tenant does not have to move when the notice to quit expires. Another common mistake that tenants believe that the expiration date of the notice to quit is the day by which they have to leave. They do not. That date indicates that that is the point at which the landlord is able to file the case in court, receive a summons and complaint, and have that served to the tenant by sheriff. At that point, the tenant gets the date of the trial, and the tenant must appear, very, very important, must appear in court on that date. If the tenant does not go to court on that date, the landlord is entitled to receive a judgment by default, which means the tenant didn't show up. It's not the end of the world. If that happens, the tenant can always later come in and file a motion to remove the default judgment. However, the tenant will need to have a very good explanation of why he or she missed the original trial date. And again, the landlord must get permission from the judge to take possession of the apartment. If the tenant doesn't show up, that's easy. They get a judgment, a default judgment, as I discussed. If the tenant does show up, there's a number of things that can happen. So what the tenant first would do is file an answer. The tenant also might choose to file discovery, which is just a fancy way of saying that they're getting more information from the landlord in order to defend themselves against the eviction complaint. And the tenant has a right to raise defenses and counterclaims in his or her answer. A little bit about subsidized housing, because that is a category that enjoys some special rights, and many of the folks you work with are probably living in subsidized housing. So a rent subsidy, simply put, is that the tenant is receiving some assistance with their rent. What that means is roughly the tenant is going to be paying a third of their income in rent, and then the subsidy, whether it be the state or the federal government, is picking up the rest of the rent. There are several different types of subsidies. There are actually many more than listed here. These are the most common ones. There's a mobile Section 8, which means the tenant gets a voucher, which the tenant can take and use anywhere the tenant wants to live in private housing. If it's a federal mobile Section 8 voucher, the tenant can actually use that anywhere in the country. Even if the tenant, for example, receives the voucher from the Worcester Housing Authority, the tenant can use that anywhere in the country. A mobile MRVP, which is a mass rental voucher program, is like a Section 8 voucher, except that it's state-based, and so the tenant can use it anywhere in Massachusetts state, but not outside of Massachusetts. Project-based Section 8 is a subsidy that stays with a unit. So that is very important because if the tenant leaves the apartment, either moves out or is evicted from the apartment, the tenant also loses the subsidy. So those are particularly important to protect. And that is also the same with public housing, which is that the subsidy stays with the unit. So if the tenant leaves the unit for any reason, the tenant loses that subsidy. And there is also state and federal public housing, and there are slightly different regulations that apply, whether it's state funded or federal funded. If the tenant has a rental subsidy, the landlord needs a good cause to evict. That is a rather gray area, but what it means is something more than just a simple violation of a lease term. And the reason for that is that the law understands that the subsidy is a very valuable thing and wants to keep the tenant in the unit if at all possible. If a tenant is evicted from a project-based or a public housing, as I discussed, they lose the subsidy because the subsidy stays with the apartment. Also important to know, though, if a tenant is evicted using a mobile voucher, the eviction can then be grounds for the subsidy to be terminated. So that's a double whammy. If the tenant gets evicted, the tenant is then at risk of losing that subsidy through the voucher. Those are also cases that community legal aid will help tenants with. I'm now going to switch over to Mandy Winalski, who is going to lead the rest of the presentation.
Hi, this is Mandy, and I'm going to give a brief overview of the federal and state laws that provide some protections to survivors in different housing matters. Now, in terms of the federal housing law, the main protections lie in the Fair Housing Act and the Violence Against Women Act, which is commonly known as VAWA. So I'll discuss those in more detail. The Fair Housing Act explicitly prohibits discrimination in the sale and renting of housing. So the good news about the Fair Housing Act is that it has a very broad application. It applies to most dwellings, and that includes private housing, which we'll see later is unlike VAWA. The Fair Housing Act prohibits discrimination on the basis of someone being in a protected class, and that's enumerated. So you can see that listed. It's things like race, religion, disability. It doesn't actually include domestic violence. So in other words, domestic violence is not actually a protected class. However, we can still use the Fair Housing Act to try to get some protection through a few legal theories. The two theories are the disparate treatment and disparate impact. So disparate treatment is exactly what it sounds like. This is where a female tenant is treated differently than a male tenant in a similar situation. This is something that would be explicit. You would sort of know it when you saw it, like a refusal to rent or a stated preference to renting to men. Disparate impact is a little trickier. This is a gender-neutral policy, so if you look at the policy on its face, it doesn't appear discriminatory. But when it's applied, it has a harsher effect on women. So the reason this is a little bit tricky is you're going to need statistics. You're going to need evidence to prove that this applied harms women. Where we see the intersection of the Fair Housing Act and domestic violence more commonly and in our own practice is in terms of a reasonable accommodation request. So if a survivor has a disability arising out of domestic violence, for example, PTSD or depression or a physical disability. Under the Fair Housing Act, she can request a reasonable accommodation so that she can enjoy her house the same way someone without a disability would be able to. This is a reasonable accommodation. And what it is, it's a change in a policy, a change in a service, something the landlord can provide to the tenant so that she's able to have equal access to her dwelling. And as a practical matter, the disability needn't arise out of domestic violence. It's anyone with a disability is entitled to these protections. What's important to know is the request for the accommodation begins a conversation with the landlord. So the request might seem unreasonable to the landlord, and they can come back and suggest something else. So it's very important to make that request to begin a dialogue with the landlord. So some examples of reasonable accommodations, perhaps there's a pet-free apartment, and as we know, service animals do not constitute pet under the law, but sometimes folks have emotional support animals or comfort animals, and these animals are considered tools. So it's important for a tenant to let the landlord know this is not a pet. This is an emotional support animal. She might have to provide some documentation from her landlord. And of course, the dog is going to have to, it sounds silly, but follow the lease. So a person could have an emotional support animal. She could have a live-in aid for assistance. She could request a transfer. All of these things would be reasonable accommodation requests under the Fair Housing Act. And it's really never too late to request a reasonable accommodation. Sometimes people don't know about it until an advocate's involved. So things that we have done are try to stop subsidy termination or stop an eviction so that we have a chance to interact with the landlord and try to figure out if there's a way to preserve this tenancy. Moving on to the Violence Against Women Act, VAWA. Unlike the Fair Housing Act, this law specifically protects survivors of domestic violence. It also protects those who are experiencing dating violence, sexual assault, stalking. And this is a federal law, so it applies to public housing authorities, private landlords only when the landlords are accepting a Section 8 or they're providing project-based Section 8, and other participants in federal subsidized programs. So in other words, if a landlord is accepting federal money, then they're going to comply with VAWA. Under VAWA, it's illegal to deny admission to someone, to terminate their assistance, or to evict them on the basis of domestic violence. So what's really important is that it's on the basis of domestic violence. This is not a blanket prohibition on evicting domestic violence survivors. It's only a prohibition on evicting people because they are survivors. So a good example, if a tenant's apartment has been destroyed by an abuser, or an abuser is making a lot of noise and bothering the neighbors, the tenant might receive a notice to quit for a case like this, and as a defense, she would provide some evidence that this is a result of domestic violence. So she has protection under VAWA in this case. What VAWA doesn't do is prohibit eviction to survivors for unrelated reasons. So for example, if a tenant just stops paying rent because maybe she's lost her job for reasons entirely unrelated to the domestic violence, or she has damages from her apartment that are just unrelated to domestic violence, the landlord can evict for that because there's no nexus between the domestic violence and the lease violation. This is another place where advocacy can be really helpful because sometimes on its face it doesn't look like what's happening is a result of domestic violence, but once you've done some digging, you can make that connection. So Section 8 is portable. That means a tenant who has Section 8 can take the voucher and move. They can move to a different state. They can move anywhere that's accepting Section 8 vouchers. The policies that restrict portability, so if the housing authority has something in place saying, here are the particular restrictions with regard to Section 8, those will not apply if a family has to relocate on an emergency basis due to Section 8. So if a person wants to transfer or leave, they don't have to, they don't have to worry about whatever the restrictions may be. And a little bit more about emergency transfers. In 2013, the President signed the VAWA Reauthorization Act, which expanded the protections for VAWA. However, it took a couple of years to actually get things into place, and actually just last month, the final rule, which is the change in HUD regulations, was issued, and it provides a little bit more protection for people who are transferring. It specifically requires that a housing provider has to allow a tenant to move immediately if there's a unit available. And of course, there are waiting lists for years, so it's common that there's not going to be a vacant unit where a person can just move. So what the law also does is it requires the providers to explain what they're going to do in this type of situation. What efforts are they going to make if no unit is available? And it also encourages the housing providers to partner up with domestic violence agencies, victim advocates, and other housing providers so that if they do find themselves in this situation, they're not just telling a person, we have nothing for you. They try to work with them. Under VAWA, the survivor can also try to have her lease bifurcated, and that would mean that the landlord evicts the abuser or terminates the abuser's Section 8 while allowing the survivor to remain in the house. If it happens that for whatever reason the survivor is not eligible for that program, she's provided some time either to move or to investigate whether there are other types of assistance for which she may be eligible. The landlord is permitted to ask some proof that there's domestic violence, and the survivor has 14 days to get them that proof, but the landlord does have discretion. They can, if it's going to take more time, 14 days is not actually a mandate. So what the documentation looks like, it could be a letter from a healthcare provider, a letter from someone with personal knowledge as to what's happening, like a medical professional or an attorney. There could be a police record that states there's domestic violence, or a court record, and there's also a HUD-approved certification form. In the 2013 new regulation that actually just came down, it makes it sort of clear that HUD is aware that documentation can be a problem because they provide that a victim can self-certify in the case of emergency transfer. So I know that some folks have had a lot of trouble getting documentation to housing providers and trying to prove that a person is a survivor of domestic violence. So one would hope that that's going to be helpful in helping people find new housing. And this information that's provided to the landlord or provided to the housing authority, it is required to be confidential unless the landlord is given permission by the survivor, or a court orders that it be disclosed, or if it needs the information in an eviction proceeding, which presumably is if the abuser is being evicted, they may need that information to prove their case. And of course, VAWA is not going to be meaningful in any way if people don't know about it. So the housing authorities and owners who are covered by this law and the managers, they have to give notice of VAWA rights to the applicants and to tenants. So when someone is denied admission, when someone is admitted, or when someone is getting a letter that has some adverse impact on the tenancy, so a notice to quit or something about a lease violation, it also includes an informational packet explaining this is what VAWA is. We can't take this adverse action if what's happening is a result of domestic violence. With that said, of course, VAWA does have some pretty significant limitations. First, it doesn't apply to private dwellings. So that means that under VAWA, private landlords can deny applications. They can evict people solely because of domestic violence. There may be other laws, fair housing or state law, that protect people, but VAWA just won't apply in these cases. It also doesn't address lease violations or conduct that's violating the lease that's indirectly linked to the abuse. So I mentioned previously that this is where advocacy is really helpful. For example, maybe the abuser pays rent and as a manipulation tactic, he's stopped. This is a case where we look at it and we see there's a clear link, but a housing authority might need to be convinced. Moving on to Massachusetts law. So this is state-specific law that exists only in Massachusetts, and these protections arise out of our laws. A landlord can't refuse to rent to someone because she moved from her apartment, maybe broke her lease and fled an apartment to escape domestic violence. And a subsidy provider can't deny assistance for that same reason because someone has escaped the apartment fleeing domestic violence. You know, we talked previously about how it's protected for someone to leave or emergency transfer. And here, when that person is running and looking for a new place to go, the landlord can't discriminate. The landlord is also required to change the locks if the survivor requests. Again, the landlord can ask for some proof, and they can actually charge the tenant. In some cases, perhaps with bigger apartment complexes, it absolutely makes sense to ask if they will waive that fee. And if the landlord doesn't change the locks within a couple of business days, the tenant can go ahead and change them herself without permission. Massachusetts law also permits the tenant to move out with written notice to the landlord of domestic violence. So she has to give some notice, but she is permitted to break a lease. It protects breaking the lease. And it does need to be within 3 months of an assault, or if she's afraid, like imminently, that living in this apartment could cause her some violence. The landlord, so they can ask for proof, but that proof is confidential. And as a practical matter, if the tenant gives notice and then decides not to leave, after a couple of months, it's going to be void, like she didn't ever do it. We talked a little bit about subsidies. So Massachusetts actual law provides that any housing program that receives state funding, so this is the MRVP voucher or state public housing, has to give priority to applicants who are facing domestic violence. Now, the wait lists are hugely long, so priority means you might get to the beginning of the list, but it doesn't mean that you're going to get housing immediately. We have seen cases where people got it immediately, but more likely there's going to be a bit of a wait. The person also needs to be otherwise eligible, so they need to fill out the application and be eligible for whatever the program is. There are also some other priorities. Some housing authorities have a local preference, some have a veteran preference, some have a homeless preference. So it's a great idea to just call the housing authority and ask what are the preferences. And in this non-adversarial context, the housing authorities can be tremendously helpful in pointing someone to other housing authorities and giving additional resources. If someone is denied, so they apply for housing and they're denied priority or admission, they have the opportunity to request an appeal. And it's not a formal court appeal, anything like that. It's a sit-down conference with the housing authority to explain why the housing authority got it wrong. So, for example, if an applicant was denied a local preference because the housing authority has done their due diligence and found that she's actually living in a neighboring town, she has that opportunity to come in, give some proof that she's only staying in a neighboring town because she's fled her abuser. And we have seen a case like that, and the person was successful in getting her voucher back. So you want to keep in mind that the housing authorities and the landlords, they have a lot of applications. There are a lot of tenants. They should be familiar with the law, but they're not going to be familiar with everyone's circumstances. So we like to treat these things non-adversarially, go in and just explain to the housing authority all the information they didn't know to try to best help people. We're not going to go over a hypothetical. In lieu of that, we're going to take some questions. And in our final slide, we have some resources available, so you can direct pro se folks to those or just take a look yourselves. It's stuff that we rely on, and it's stuff that we recommend. So I think now we will turn to questions.
Okay, give us just a moment. We're looking at the questions now for the first time. Okay, so we have one here, how do survivors determine which subsidy they would be eligible for? That's a great question. One thing that Mandy talked about is that for state public housing, there is specifically a priority for domestic violence survivors, and that is not necessarily the case in other programs. The federal programs allow the housing authorities to make that a priority but do not require it. So that may be the first choice. This is really where you all could come in handy with some assistance from us, because it gets further complicated. It's not always easy to know which of the projects are state and which are federally funded, and that often takes. Sometimes it's on good websites for the bigger housing authorities, but sometimes it takes a call to a housing authority to ask that kind of a question and to help people negotiate the process. Let's see, I'm looking for other questions. Let's see. And we have, where can you find guidelines for federal poverty levels? Great question. So if you just go ahead and Google that, federal poverty guidelines, you'll find it pop up on many different sites. Those are, as it suggests, those are set by the federal government. We have a chart here that we use that actually does the math for us, that tells us how much is 200% of federal poverty guidelines, because that is the number we're allowed to go up to if the person has additional expenses. So if that's something that would be helpful to anybody there to have, please just feel free to email me after the webinar, and I'll give my email now. It's Dieringer, which is JDIERINGER at CLA-MA.org. And give us a minute, and we're going to keep clicking through the questions. Okay, and this question is, you said VAWA applied to housing authorities. Could you clarify? You only mean the federally funded projects and housing authorities, not state-funded projects, even if the housing authority has both federal and state, correct? VAWA applies to state and federal public housing. So VAWA protections are federal, and so that covers all state and federal. So that is going to be the most protection you can get, and therefore is going to cover state and federal. Not to confuse things too much, but we just mentioned a moment ago that the state law gives priority to domestic violence survivors that are on wait lists, and the federal does not. So the state is permitted to give more protections than the federal government is, but with VAWA, because it's a federal law, it necessarily applies to all state and federal public housing. We have another question. What are the circumstances in which a housing authority may provide a victim of domestic violence living in a project-based subsidy may receive a mobile voucher for their safety? We have struggled with this for many years in different contexts. I think that the answer is that they have the capacity to do it if they want, but I do not know of any regulation that requires them to do that. The way you would know, there's no federal regulation. The housing authority itself might have a policy, and you would find that in their administrative plan, which again can sometimes be hard to find. The bigger housing authorities may have them online. The smaller ones would only have them in their offices. But I don't know of any regulation that would require them to do that. I think that would take a lot of advocacy. And I think what they would probably say is that the wait lists are so long they can't possibly do that. How hard is it to get subsidies at this point? Another great question that doesn't have a really good answer. It's still very it's very siloed, the way the subsidies are given out. There is one standard list for some housing authorities, but many housing authorities do not use that standardized list. So what we encourage folks to do is to apply to as many housing authorities that have Section 8 vouchers. Some of the smaller ones don't have any vouchers at all. Apply to as many as you possibly can. I will say anecdotally that it does seem like the smaller housing authorities have shorter wait lists. And again, what I will say about the federal, the Section 8 vouchers is that those can be used anywhere, so people can move out of state. But even with the MRVP vouchers, which is the state voucher, those can be used anywhere in the state. So you might get a voucher from the Orange Housing Authority, for example, but not want to live in Orange, and that's totally fine. People, I think the tenants don't often understand that they can use their voucher wherever they want. But what I will also say is that tenants often don't understand that there are different types of subsidized housing. Tenants have often heard of the Section 8 voucher, and so they put their name on wait lists for that, and literally some of the wait lists are years and years and years. Oftentimes the wait lists are completely closed, so people don't even have the capacity to apply to them. What I would encourage you all as advocates to remember and to think about are the project-based subsidized projects. And you can do some Google searching for that, or email me. There are some lists. There's no great one-stop shopping for it, but folks who do this work at like legal aid advocates generally know where the project-based subsidies are. Folks are going to have better luck with shorter waiting lists for the project-based subsidies than they are for the vouchers. They're going to be able to get in there quicker. It's in some ways not as good because you don't have any portability. You don't get to use it wherever you want. The voucher stays with a unit, but it's a subsidy in that you are only then paying a third of your income towards the rent. Okay, it's weird not to get any feedback, but you all are muted, so I'm just going to keep going through questions. Here we have one. What constitutes a tenant? If a victim is residing with their abuser, the abuser is the only person on the lease but has been vacated under a 209A order, do any of these protections apply to the victim? It sounds to me like in your fact pattern, I can't be sure, but if I'm reading it correctly and the victim or the survivor is living there unbeknownst to the landlord and is not on the lease, then she is what we would call an unauthorized occupant and is not actually a legal tenant. So I do not think in that situation the law would apply, any law would apply to her, and that the landlord could probably pretty easily evict her. Okay, great questions, by the way. Thank you. When you talk about reasonable accommodation for a disability, how does this apply to domestic violence when requesting a reasonable accommodation? Is it considered a mental health issue? Another really great and somewhat complicated question. Domestic violence itself, or being a survivor of domestic violence itself, of course, is not a disability per se. What we see very often, and I know that you all do as well, you're probably certainly more expert in this than we are, but what we see is survivors who are suffering from anything ranging from PTSD, post-traumatic stress disorder, to anxiety, to depression, to many other diagnosable mental health issues. The issue there is always going to be getting a diagnosis from a professional. In order to request a reasonable accommodation, you're going to need some documentation from a professional, a treating therapist, psychologist, social worker, doctor, that gives a diagnosis. And then what the advocate is going to have to do is create the nexus. It's not enough to just say somebody has a disability. There has to be a nexus between the disability and the behavior. And that can be broad, though. I don't mean to be negative about that. That's really where advocacy comes in handy. And sometimes the treating therapist can be helpful with that. An example of this is a survivor of domestic violence stops paying rent. On the face of it, it doesn't necessarily look like it's connected to any disability, but if you start to tease it out and you start to see that, the domestic violence began at the point that she stopped paying the rent, you start to make the connection that her ability to pay the rent is somehow connected to the domestic violence. It could be that she's suffering depression, or that things are so chaotic in her life she's unable to continue to pay the rent, but that connection has to be made. It's not enough to just say this person has a disability, therefore they should not be evicted. Let's see. So another question, how, if at all, do these rules apply to survivors living in shelter programs? Shelter programs have their own list of rules and regulations, and also have a whole different way of appealing if the shelter is intending to terminate the person from that shelter. But certainly any federal laws like VAWA and Fair Housing Act that covers reasonable accommodation would absolutely apply to shelters as well. Please repeat your email address. Thank you. That's an easy one. It's Dieringer, Dieringer at CLA-MA.org. And the follow-up to the question is, thank you, you're welcome. And can we get a copy of the slide information? Absolutely. The organizers, Amy and Barbara, will email the slides to everybody who's on the call. Let's see. Okay, this is another really great question. Thanks, everybody. What should we do as advocates if, for example, the local housing authorities are not providing VAWA information to tenants? I think probably nobody on the call will be surprised that, the housing authorities are not always forthcoming about information about folks' rights. And I want to err on the side of being glass half full about this, that the housing authorities are overwhelmed with a million different documents and requirements, and that it's not intentional, but rather them being overwhelmed by other things. However, I think that kind of advocacy, if you are willing and able to do it, can be incredibly helpful. What you can do is ask to meet with a director or whoever might be directly in charge of programs to talk about that, and to see what they're willing and able to do. As we talked about, it's actually a requirement that they provide the information. So if they don't, if they're refusing to, that might be an issue that community legal aid might be interested in. You can certainly contact me. And what I would think about doing, either from here or any advocate who wanted to do this, is to reach out to their funder. For state housing, it's DHCD, Department of Housing and Community Development in Boston, and for the federal programs, it's HUD. How that all shakes out with the new administration is anyone's guess, but that's where we would go. Okay, somebody is writing in with helpful information. HAP is on this webinar. Welcome, HAP. Hello. There is a low-income housing search workshop on December, hang on a second. Correction from HAP. There's a low-income housing search workshop, which is wonderful. This is really exciting that you're doing this. Thank you. It's on December 6th from 1 to 2:30 p.m. at HAP, which is located in downtown Springfield at 322 Main Street. Thank you so much for sharing that. And that's for folks who want to learn more about finding low-income housing for clients, which really, from our perspective here, is incredibly critical work. There are not a lot of agencies that are doing housing search, and there are a lot of hoops to jump through for folks to fill out applications, and like we talked about, to even identify where subsidized housing is. So I highly recommend this, and I really thank HAP for doing this. So additional information is you can contact Natalie Vincenzio, sorry if I'm pronouncing that incorrectly, for more information. I'm going to give you a phone number and an email address. The email address is nvicio@haphousing.org. I will repeat that. It's nvicio@haphousing.org. And the phone number is 219-8959. Thank you, Natalie. All right, I'm going to keep scrolling down. Talk amongst yourselves. Oh, somebody else, very helpful information. Mass Housing has a full list of private landlords and complexes that provide subsidies. That is wonderful. I do wonder if that includes federal as well, but it sounds like maybe it does, and that's great. Follow up to a former question, can domestic violence survivors then get a transfer from a state project-based or state, I'm not sure what that means, state project-based to a federal project-based? I think if I'm understanding the question correctly, the answer is no. There's no right to transfer between state and federal. I'm scrolling up now. Oh, which one? Second to last. Can reasonable accommodations only be used in public housing or when the tenant has a voucher? Another great question. So reasonable accommodations springs from federal law. It's the Fair Housing Act. There is also a similar state law, but the important reason to know that it's federal law is it means that it applies to everybody. And so that means that, yes, reasonable accommodations can be used in any kind of housing at all, private housing, public housing, subsidized housing. I think we may have covered all of the questions. Sorry, I have a tiny little panel I'm scrolling through.
And I just sent you another one that just came.
Okay, thank you, Amy. Oh, another really helpful feedback, and thank you all for participating, even though it's hard to do that on a webinar. Stavros provides housing workshops monthly. People can contact Jim, I'm sorry, so sorry, Jim Waleko, I believe, at 1-800-804-1899, extension 216. And for folks that don't know, Stavros specializes in working with folks with disabilities, and is an absolutely wonderful organization. Okay.
Does anyone have any further questions?
Now is the time to
more minutes. If you do, well.
And if I missed it, I apologize. Go ahead and retype, and I will answer now.
And while we are waiting to see if anyone has any final questions to ask Jen and Mandy, Amy Waldman and I really want to extend our incredible thanks to Jen and Mandy for doing this workshop. It's our first webinar in our series, and they have been just the most fantastic people to work with and a really important resource.
Thank you. You are too kind.
Well, thank you. I've got like one or two more comments, so I'm just going to send that over to you.
And while Amy is typing, I just want to say, I should have made the remarks in the presentation itself, but that the vast majority of tenants are unrepresented. As I said, we are the only civil legal aid providers in Worcester and West. That sounds hard, but what I will say is that there are amazing resources in the court. First of all, community legal aid is in court almost every session, and folks can approach us, you know, up until and including the day of their trial, and we can often help. Tenants can also ask for mediation assistance, so they will sit with a neutral party who works for the court. They're called housing court specialists, and they are often able to mediate agreements. What we find, at least in Western Massachusetts, and I think we're very fortunate for this, is that landlords and their attorneys often want to come to some sort of an agreement. There's a problem and they want the problem to be fixed. If the tenant can fix the problem, or legal aid or the tenant's advocate can work to help fix the problem, and oftentimes that means reaching out to you all to help, the landlord is more than happy to let the tenant stay. So when a tenant gets a notice to quit, I think their first reaction is panic and fear and anger that this happened, but I think in many situations they can be reassured that if the problem is fixable, the landlord is often willing to sit and listen to a solution. And the place to do that is in mediation. So when they go to court, they should ask for mediation. There are other great resources in court I'm going to go over really quickly since we have the time. There's Tenancy Preservation Program, which works specifically with folks with disabilities where the disability is affecting the tenancy and is likely the underlying reason for the eviction. TPP is unbelievable. They can connect people up with all sorts of services that they probably have needed and haven't been able to connect with in a while. And community legal aid works very closely hand in hand with TPP. So legal aid will work on the legal issue while TPP works on the non-legal issue. And very often we can not only fix the problem underlying the eviction, but can give folks the kind of stability that they haven't had in their lives in a very long time. In some of the courts, veteran services is present, and they can also be sometimes very helpful. And I also want to give another shout out to HAP Housing, who in the West, in Hampshire and Hampden County, runs the RAFT program, and the RAFT program is available across the state, and it's organized by different agencies depending on where you are. And what they will assist with often is rental arrearage, paying off back rent, helping with first, last, and security for folks to move into new units. And then community action, which covers Western Massachusetts, also has a similar program, and it can also often help with utility payments. And I'm going to check now to see for new questions. If you have time, any comments on repairing credit up for survivors of domestic violence since they can be denied based on credit issues? That is a little outside of, I think, the time that we have, and to be honest, my area of expertise. I do know that it's a huge issue for folks, and I would point folks to the online resources at National Consumer Law Center, nclc.org, which is based in Boston and does wonderful work around credit. Oh, and this is a nice one. Thank you from Cheryl LaChance. Thank you, Cheryl. And let's see, here's another one. At what point would you suggest putting in a reasonable accommodation for an application with credit or other issues involving domestic violence? When submitting application or after denial during appeal? I'm not entirely certain I understand the question. But what I would say in general is that if you think there's a reasonable accommodation request to be made, make it right away. Landlords have an obligation to engage in an interactive process with the tenant at any stage, before the eviction begins, during the eviction, even once they get to court for the trial date. If the tenant brings up a disability for the first time that day in court, literally, judges, at least out in Western Mass, I will say they're quite wonderful, will send the parties back out into the hallway to talk about the reasonable accommodation, even if it's being raised for the first time in court. So you can never start too early, and you can never ask too late. But what I also want to say is, and I'm not exactly sure I understand the question, but that again, remember that the disability has to be connected in some way to the underlying issue in the eviction. And earlier question was, any comments? Oh, okay, I answered that, sorry. This is great too. Thank you once again to HAP. HAP reports that they also assist folks with fair housing questions, including reasonable accommodation in domestic violence cases. Call anytime, and though we don't represent people, we give a lot of great information and at times referral when necessary. Thank you for that. And what I should say about fair housing is that all of community legal aid deals with fair housing in the context of evictions if there's a disability underlying the eviction. But that in the Worcester office, we also do affirmative fair housing cases. And in Western Massachusetts, the folks that do fair housing cases is the Mass Fair Housing, and they're located in Holyoke. Is RAFT only for families? Yes, RAFT is only for families. although we think we understand, and perhaps somebody from HAP, oh, and here she is, maybe Natalie will answer this, we believe that there may be a new regulation that allows them to help individuals. For folks in Western Massachusetts, community action will often help individuals. And the last, I think, will be the last question. Applying for housing, and I think the question is, a tenant is applying for housing and has bad credit, so will be denied. Credit related to the domestic violence. Accommodation at application or after denial of application. I think the credit is going to have to be repaired. I think that is not a. I have never tried it before, but I don't think there's a close enough nexus between the domestic violence and the credit to excuse the bad credit in order to get into the housing. But I have never actually had that come up, and I've never thought it through carefully, so I don't want to say more than that. I'm sorry, that's just a terrible note to leave on. Okay, I think that's it. So I will thank everybody so much for your great questions and your great feedback and help. And really thank you all for all you do, because really we as lawyers at Legal Aid cannot do what we do for our clients without working collaboratively with you all. And we really just so much appreciate the work that you do and love working with you. Back to you, Amy.
And this is Barbara, but Amy and I would again like to thank Jen and Mandy so much for doing this wonderful presentation, and for all the participants. This has been one of the most interactive webinars, and everyone asked very, very good questions, and I think there was a lot of great information sharing that happened this morning. So we will email the slides from today's presentation to all of you who are on the call, and just stay tuned, because we will be having future webinars about economic security issues for survivors as part of this series. So once again, thank you all very much.